Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under false
answer and counterclaim to what?
To their complaint for eviction.
You have a lease allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against.
Okay.
Or whatever the heck you're doing. Because there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Okay, I'm not really understanding, but.
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case, and grant an order of a judgment and an order of eviction in 10 days.
Okay.
Any claim of your interest in that property, you have to go after the Whitlows, because that's the only person you have a contract with. Allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay. I know you don't know that. It's not before you.
Correct.
I see. So basically the notice of removal that the Whitlows did,
they are not here. I don't know. I have documents that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, deny, and it should be denied also on the merits of whatever their motion is. But I could deny it because they're not here.
Okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No,
You're telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything, and I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with the writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.